Cool. Okay. Like I said, it's been a very fast moving last 7 days. Uh, and this is the reason why. And I want to explain the significance of this. So can you all see this general form of judgment or order in the county court at Maidstone? Can you see it? Can
Yes.
somebody?
Yeah.
Yeah.
Yes, can see it.
Right. Firstly, people, we'll talk about this, but you can see this has really made, you know, the cockroaches come out of the woodwork or whatever, or I don't know, out of the drains or whatever. And you can see a huge lack of knowledge as to what goes on in the courts. So, for instance, there have been accusations this isn't a case because it says claim. Okay. So, if we just start with that, you have one person making a claim and somebody else is defending against a claim. These different words have been used over time for this, but essentially, simply, one party makes a claim, a belief, their belief, against another party. So some people reckon this is all nonsense, what we put out on the video, because we've used the word, because they believe that there's no case number. Of course, there's no case number, because the only the magistrates and Crown Court have cases of criminal matters, or can be civil as well. But you outside of the magistrates and Crown Court, you won't hear case. It's not a word they use. So when you see all these people, criticizing or doing that, they don't even, you can see they've got no idea what's actually going on in the courts. But one party lays a claim, and it used to be, people will still be familiar with the magistrate's court of complaint. That's where the word plaintiff comes from, or the word complainant. And the word respondent is the person that responds to somebody else's complaint or claim. That. Okay, so that's the first thing. So this is Jamie's order, which we received today. And the reason we received it today is because it takes time for the court to actually produce the document. Okay, but it's dated the 7th of March. Okay, so this is, for all those people who don't know the difference, this is the number of the case you need to look for, claim that you need to look for. Okay, you're not going to find it on CourtServe because CourtServe doesn't keep a history of it. So you're going to have to go elsewhere, and I wouldn't know where. So this here's the court seal. So this here's what's called a perfected order. And this difference between what's called an extempore order and a perfected order, people need to understand. Okay? A perfected order is enforceable. This here is what creates the law between the parties. Okay, so when they talk about a liability order, unless it's perfected, it's not legally enforceable. All right. So what Lucy was asking earlier, when they say a verbal order is good enough, no, it ain't. Okay. So the claimant, you'll see often they'll use first. If there's multiple claimants, it might be first claimant, second claimant. So like Tracy and Norman, Tracy was first claimant and Norman was second claimant. You can have the same thing if you've got multiple defendants. You'd have a list of first defendant, second defendant. And if there's interested parties, you'll have first interested party or second interested party. So the claimant was Maidstone Borough Council. Now they applied for a final charging order. Okay. So this hearing was about did they get what they asked for at the hearing? They wanted a final charging order, and as we'll show you, no, they didn't get what they'd asked for from the court, and therefore Jamie won. This hearing, Jamie has won. We've never made any further claims beyond that. So hopefully people actually start to realize when you read a lot of this nonsense that's going around, and we'll talk about that in a minute. So basically on the 7th of March 25 before, now what is a court? A court is a judge, somebody that's under oath. Okay, if it's not under oath, there is no court. So it's actually the judges, and in the magistrates' court, if it's lay magistrates, for certain things, they need a minimum of 2 magistrates to sit. For other things, they may need 3 magistrates to sit. So to make an order in accordance with Regulation 35(6), it requires at least 2 sitting magistrates. And guess what? They sit somewhere, okay? And that's why you'll see sitting at, and then it'll have the court name, the building, okay? So without the name of a judicial officer, by impossibility, there can be no court order. But again, it highlights not only with these alternative truthers, but even within the legal profession and even within the judiciary, the judicial officers themselves, they do not understand the basics of law, the foundations, okay? Now, an extempore judgment or a verbal judgment, and this is discussed, we've discussed this with Tracy Norman's case, and I will actually continue and make a separate video on what's called the slip rule and corrections, because people also need to understand that, but more importantly, judges need to understand it because they really don't. I've not come across many judges that actually get that yet. So an extempore judgment is a verbal judgment, and a judge retains jurisdiction over that verbal judgment and can change their minds. And there are cases where judges have done the same thing, where on reflection, they've thought about it and thought, darn, I've made the wrong judgment. And they've been big enough to correct their mistakes. But and under what's called the corrections on the civil procedure rules, you can correct an extemporal judgment or a draft reserve judgment or a reserve judgment or a draft judgment. They use different names for the same thing, okay? But to be perfected, it needs the seal of the court. And put in to writing. So is everybody clear what a court is? It's a judge sitting. It's not a building, because by impossibility, a building can't do anything. It can't act. So therefore, it can't make a decision. So it continues then. It says, upon hearing Gail Edwards, the solicitor for the claimant, and Mr. Jamie with his Mackenzie friend, and both parties relying on bundles, neither of which made into the court files. Basically, our bundle, we emailed at about 3 o'clock before, and so and we'd received nothing from the solicitors.
Mark, the audio did not catch that you said that it was the day before at 3 p.m. that you submitted the bundle.
Yeah. Okay. So yes, they didn't have much time, but at least we'd got it in. The solicitor gave us, before the hearing, okay, so we were in the court, her bundle. And it turns out she hadn't even given it to the court, to the judge. So both Jamie and Gail were quite rightly told off with the judge by the judge, but give the judge's dues, he gave them both a telling off. Okay. So there were two issues that we've got. The first issue that Jamie made was whether the magistrates court did in fact make the liability orders below in respect of council tax or not. Okay, now just go back to what I said about a perfected judgment and a verbal judgment. The council tax regulations say the judge must make the order if they're satisfied that a sum has become payable and has not been paid. Now, that is all the order actually says. The judge has no authority to make a liability order. Okay? There is no authority in there for a judge to make a liability order. The way that they do this is through the interpretations. A statutory liability order is created from the order made by the judge. So the judges and the magistrates do not make liability orders, and they have no authority to create a liability order either. Okay, it's a pure statutory creation, a creation of statute where the judge's order, if the judge agrees a sum has become payable and has not been paid, then they make an order. Then statute law converts that order into a liability order. Nothing to do with the judges, nothing to do with the magistrates, but they have no idea what's going on. So that's going to be one very interesting thing to see how they deal with this moving forward. So in this case with Jamie, there were 3 liability orders, one dated 30th of August 2019, made in Sevenoaks Magistrates Court. Next one, 24th of August 21, made in Medway Magistrates Court. And the third one made on 12th of October 22 in Maidstone Magistrates Court. So the defendant, Jamie, accepted he received a copy of the claimant's paperwork in support of the application for the charging order. Okay. And those of you that have been following what we've been saying on charging orders, okay, we do not accept these are the orders made by the magistrates court. That's the issue. There is no perfected order from the magistrates court. All that's given is evidence of the council's paperwork. And latent judgment affirmed by COFA, there's a difference between evidence of a liability order being made and the actual order. So in Leighton's judgment, Wayne's judgment, he was clear, the judge, on the balance of probabilities, i.e. inequity, in good faith, if the council says they've got an order, you can start commencing under the rules of equity on the belief that they are not lying, or that they believe it is really a liability order. And that's the situation we have. The councils think, they believe that it's a liability order, despite the fact that all the guidance, the magistrates court rules are clear and the guidance from HMCTS is clear. The judges, the legal advisors do not sign any council paperwork, yet they still do this. They can't even read their own guidance. Okay, they have no idea what they're doing. That's how simple this is. Anybody that thinks it's corruption or hired courts or hired judges and that, it's utter nonsense. They just have no idea what they're doing. Okay, the defendant further says he emailed the magistrates courts for the orders, but he has not received a response. Remember 2 years ago, we were going through to try and get hold of these alleged orders. Okay. If he is provided with copies of the court orders listed above, or the courts confirm in writing to him with a certified extract from the court register with the name of the magistrates that made these orders, he will be satisfied that the liabilities were court orders of the court. Why? Because Jamie believes in the rule of law. If there is a perfected order from the court, that is what creates the law. Acts of Parliament are not law. Otherwise, you would not need an order from a judge to enforce it. Okay? So you need look no further than that. That legislation is not law. Law is created in one place and one place alone, in the courts of law. The orders are what create the law. And precedent is what we are all subject to, the common law precedent. Okay? Now we've got two arguments. The second argument is the claimant, i.e. the councils, are not entitled to any interest payments on charging orders, on bankruptcy orders or bankruptcy petitions. And I think that's the only two that they try and charge interest on. There's the Powers judgment from 2018, which makes this absolutely clear, that only the regulations enforcement part of the regulations, whatever part, I'm not bothered to look it up if somebody off the top of their head knows. I think it's part 6 or whatever it is. Anyway, in the council tax admin and enforcement regulations, one part is called enforcement. You cannot go outside of that. And in 2018, in the Powers judgment, they ruled exactly that. That is the only authority they have to enforce council tax. They cannot go outside of it. So at the time, there was no Courts and Tribunals Act 2007. However, they've included that now, whenever they did it, into the enforcement section of the regulations. Therefore, they can enforce using that method. But if there's something not in there, they cannot do it. Okay? So our second argument is this is in relation to charging orders. Nowhere in the regulations does it say that they can apply interest. Therefore, all interests, payments made or taken or charged are unlawful on charging orders. So this here is basically what went on in the court. The judge's words, not my words. So based upon what the judge saw before him, he made an order. This is the law. Okay, it's ordered, one, that Seven Oaks Magistrate Court, Medway Magistrates Court, and Maidstone Magistrates Court, i.e. the three courts who made these alleged orders, shall provide copies of the court orders or provide certified extract from the court register to include the names of the sitting magistrates who made the orders within 28 days of service of this order. Okay, so that is what is significant in this judgment. We didn't push costs because this year is far more important than costs. We'll push costs on the next hearing. Okay. So what this is doing is the county court has now accepted council paperwork is not acceptable for enforcement, which is exactly what was said in Leighton's judgment. And in Sharon's judgment, the judge also made it clear that there's a difference between evidencing an order and to be able to put on, for instance, a charging order or a bankruptcy petition, or even an attachment of earnings, or even taking your council tax from your benefits, or guess what? Imprisonment. Unless there's a perfected order, they cannot do any of that. I.e., we are forcing now, as this news gets around, the names of the magistrates who are making orders which are statutorily converted into liability orders. I'll come back to that point, but that's the significance of this, and that there is very, very significant. Okay. What he said was both parties shall serve a copy of this order on the named courts. This is to make damn sure that, let's get the orders. Now, this goes against the principle of he who asserts must prove. Okay. However, for this single, it's a game of chess. All right. We didn't need checkmate. What we needed was an order confirming exactly what we've been saying. A perfected order is what creates the law. That's the difference between lawful enforcement and cowboy actions which they're doing. But now it's clear in law. People will say this is not a precedent in the county court. Guess what? They do not understand stare decisis. Stare decisis is to stop discrimination under the law, i.e., all are equal under the law. And it works in two ways. You have horizontal stare decisis, i.e., within a court, everybody must be bound, otherwise they'll be discriminating against people by unevenly applying the law. So if another county court does not uphold this, they need to give very good reason why they believe this order is wrong. And this we'll be testing tomorrow with Buckle's case. So we'll actually be using this order tomorrow for to try and get 2 charging orders thrown out. And vertical stare decisis is what comes from the top applies all the way down. Therefore, under the principles of stare decisis, all courts, lower courts, must abide by higher court decisions. And within those courts, if there is not a higher decision, when a decision's made, they must apply it equally across that level of the court. Otherwise, they're discriminating under the law. So when they tell you county courts and magistrates' courts, they don't follow precedent, they are wrong in law. That is the foundation of our legal system, stare decisis. Logic and reason applied to the evidence. Okay, so that's hopefully now people understand that this actually is significant. The legal profession don't get it yet, and they keep on using it as excuses, which is why when you go into magistrates' courts, it's a toss of a coin. They'll do what the hell they like because they really have no idea what stare decisis is, the foundation of our legal system. Perfect. Because without that, then you have discrimination under the law. Stare decisis is the only way that I've come across where you can equally treat all equally under the law. There's no other way that you can do it. So that there is going to finally sort out. Again, this has been going for hundreds of years. Nobody's ever brought this to the forefront. It's so fundamental. Okay, the defendant shall pay the relevant fee if applicable. This here now is going to really cause another issue because the certified extracts cost 20 quid. And they are in the bulk orders, the bulk listing, well, for even individual liability orders, the claimant, the councils, pay 50p per order made by the court. So what this is going to start is they're going to force any enforcement by the councils requires a certified extract or a order made by the court, i.e. with the names of the magistrates on it, without which they cannot enforce anything anymore. So they do have an HMCT guide, but not in the admin and enforcement regulations that costs can include a notice of liability order. Those of you that have been following the process know that when you get a notice of liability order, you tell them, this isn't a liability order. Where is the liability order? So this should not affect the costs at all because they do not need memorandum of a certified extract from the court record. So for about £1 instead of £20, all they need to do is the judges, the magistrates who make the order, authorize the council to print out the template on letterhead. Don't forget, they do this at the moment without the letterhead. So they just need to get the court authority to print it on court letterhead, i.e. under the seal of the court, with the names of the magistrates who make them. That's how easy it is to fix this problem. Okay? Now you're going to find out, though, if there's a will to actually fix this problem. So at the moment, and again, didn't want to argue it, because this money will get back. What if they do manage to produce a magistrate's court order, then, you know, the costs are added. So whether Jamie pays for it now or later makes no difference. If they don't, if they can't produce them, then the outcome's very different. Then District Judge Lutfur Rahman, he's ordered for the next hearing, the first open date after 8 weeks, with a time estimate of 1 hour for a face-to-face hearing. Then what is also ordered is that both parties file a skeleton argument, no more than 4 sides, and any bundles a minimum 7 days before the next hearing, i.e. he can read and see what the case is all about before he walks into the court. Okay? And then all the rest is irrelevant general stuff, which you'll see on every court. And the order is dated 7th of March. Okay, so has anybody got any questions on that? Anything, anybody? No? So we understand what stare decisis is now. We understand what common law precedence is now. We understand what an extemporal verbal judgment, not enforceable. We understand what's a perfected judgment. A judgment with a seal and the names of the justices that make it. Without the names of the justices, it is not an order of a court. So this here is going to force names of magistrates out into the public. And the significance of that, because yes, they can fix this problem like this. It's easy to fix. They just need to change the template that they print. So this can be finished, you know, in no time at all. So you've got limited time now, okay, to put in your claims against enforcement agents. So if you've followed the procedure, you can put in your claims against enforcement agents because this order has won you the case already. Because we know they've come without court orders, without perfected court orders. Okay, here's your precedent. Now they have to follow it. So any of you that have got on the final notice of with enforcement agents, here's your 10 grand. So we've got James's on the 2nd of May or June. Hughes, we'll talk about this weekend, but he needs to push his into the court so that he can get his done. Brian's putting 2 claims in because there's loads of people that think that Brian's not paying his council tax. Sorry, is paying his council tax, but he wouldn't be able to put in 2 claims if he was, because there would be none. So that's so they're going to be forced. They've got to change their system. They need the names of the magistrates. Without that, there is no perfected order, and therefore there can be no lawful enforcement. So this may well knock 3 to 6 months into their revenue stream alone until they get their act together. So those people who think it's all insignificant and irrelevant and stuff like that really have no idea how the law operates. So I think, Petter, you've got a charging order. Okay.
Sorry, they're threatening, not quite yet, but
Well, here's your solution.
yeah.
Okay. Without the perfected order, all of them fall. Okay. Robin.
I just wanted to say that the reason that it's as dangerous as it is because we're a group and people are getting judgments or they're getting results and we all know about it. So it's not like it used to be where people wouldn't know what had happened.
Yeah.
So they couldn't change the process as they're going along. And
well, there was no need to change it before. Now there's a need.
Yeah, because people know.
Correct.
Yeah.
Knowledge is power.
Yeah.
Absolutely, Robin. Yeah.
That's what all I was wanting to say is that that is the reason, is that we are all doing things that is unescapable.
Yeah, they can't stop this. Technology is going to sort out the rule of law. It's as simple as that. Daniela. And
Hi.
Emma should be having a big smile on her face because her solution's already dealt with. Robin? Daniela, sorry.
Thank you for the presentation. It's really timely for quite a few of us.
Mm-hmm.
We are at the moment where we are waiting for the court date. So we are going to send what you put together brilliantly last week. Shall we add the order to the document?
We've got to update it to include it, yes.
But if we do it ourselves, it's okay to put the order.
Yeah, okay.
In that
Now,
document.
basically, okay, we need to attack also now the costs. Now, what was interesting was at Carrie's case, now correct me if I'm wrong here, Carrie. Is she still here? I'm not sure.
Yes.
When we arrived at your case, wasn't the first thing she put in your hands a statement of costs?
It was on the back of her submission.
So she submitted on the morning before we walked in a statement of costs.
Yeah.
You did not do that with Jamie. No statement of costs.
Ah.
So she knew she was on shaky ground. Okay.
Yeah.
But anyway, basically the point is, Daniela, we're going to start claiming costs back at what they throw at us. And that we will be taking, they won't like that because they only will give you £19 an hour. But that they will go to the High Court, and under the rules of equity, they have no choice but to pay us for better service. If we beat them and they want 5 grand, we get 5 grand and 1 penny, and they will have no choice. That they will start to bring this whole nonsense about these stupid costs into proportion as litigants in person started beat them.
Okay, but until then, I'm going to add to the document this order.
Don't send it until 2-3 days before the hearing.
Oh yeah, no, yeah, I don't, because I don't want the council to be aware of our strategy.
This is going to take time to filter through. We'll talk about manifestation once we've finished this.
Yeah.
You know, I want it on the video, but once we've finished this.
Okay, but it's okay to be kind of used as an argument
Yes,
in our defense.
this is public record.
Okay, great.
Anybody
Okay,
can get a copy of this order. It's public record.
great, thank you.
Yeah.
Well done again.
Well, no, everybody well done.
I know,
because-
well done, everybody, of course.
Yeah. Right,
But
Emma.
you for holding everything together.
Right, Emma, do you see where your immediate problems resolved?
Well, yes and no, Nick. Yes and no. Because I wrote and asked for the judges that the justices that.
Not your problem. They making the claim. Don't push it. Don't do anything anymore with it.
Yeah, but no, what I'm saying is they've written back to me and they've given me the justices that signed off the liability orders.
So it's got the names of the justices on.
Yeah, and the court extract.
And the legal advisor's name?
Yeah, I think so. Yeah, just not their full names, but their first. Their
No, it needs their full names.
Yeah, so they haven't. But she said to. Well, it says on the letter they don't have to by law.
No, they do have to. They have to be identified.
Okay, so should I write back
But
again?
anyway, okay, so it's not going to resolve your issue, but we'll come back to yours.
We
Emma.
need the case number. We need the case citation, Mark. Emma, I'll find the case citation where the legal advisor. I think it's the L&B ruling. Just
Yeah,
drop me a
I-
message. Remind me on knock to share that with you. I think it's the L&B ruling.
So maybe already they're starting to get the message. Okay.
So don't.
What's your
sorry.
question, Emma?
So don't do anything now. Still, don't do anything, or write
Well,
back to them.
if we do a Zoom over the weekend like we arranged last week, and we're just got to go through everything and then just see what options you got.
Yeah, I'd like to have a look at them, Emma. I'd like to see what they've drummed up.
Okay, I'll forward them to you.
Yeah.
Thanks.
What day is good for you, Emma, over the weekend?
Any day. Yeah, I'm not doing anything this week.
Okay, well, we'll have to sort it out.
Yeah.
Okay.
Cool.
Okay. Any
you.
other question?
No,
Emma?
no. Well, no, because I won't take up your time tonight. We'll leave it
Okay.
for the weekend.
Yeah.
Thank you.
Okay. John, speak to camera.
Hello.
Hi.
How's things going? This is all great news. My thing is that it's got to charging order, and it's got
Final
to
charging order?
final charging order and land registry.
Made by CNBC or by a judge?
It was in the county court.
Yeah, I know it's both of them are the county court. Was it before a judge or was it made at the National Business Centre?
Sorry, National Business Centre. Yeah.
Yeah. Okay. It's not a judge that made it. It's not an order of a court.
Yeah.
So you have automatic, set aside rights. You need to request it to be brought before a judge.
Okay.
And then with the evidence, you can point out to with the evidence as presented, okay, it is, unless it's got a perfected order, does not meet the requirements of section 50, subsection 1 of the regulations, and therefore they must dismiss the whole katuti.
Even if
They
I've gone
can't give them now, they can't give them another chance. They need to dismiss it because their claim is totally without merit.
Okay.
Okay.
Even if I've gone to court and appealed it and still got thrown out, it's still
I know if you've appealed it already. I thought you said it was
Yeah,
made.
no, I have appealed it, but it was absolutely fast, the appeal.
Were you before a judge?
Yeah.
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 Okay. So that depends on what paperwork you put in. I don't know what paperwork you put in.
Well, yeah,
It
was saying my whole thing was these aren't liability orders.
And have you appealed that judgment to a circuit judge? Same as Curry's doing.
Appealed the appeal.
Hang on. Sorry. Okay. So you've had one appeal.
Yeah.
So you've been in front of a judge twice.
Okay.
Have you been in front of a judge twice?
Yes. Yes.
Okay. So next thing is you need to appeal it to the High Court.
Okay. That's what I need to know. Yeah.
Yeah.
Okay. And that costs presumably.
Well, all of it costs.
Yeah.
But the point is that order itself, okay,
Not valid.
is not valid.
Yeah. Well, I kept on telling them that, and they didn't listen, of course.
No, I know. But now this is the the second thing. When the third one comes along, that's our new reality.
Cool.
Okay.
All right.
But we'll talk about that in a bit. Hugh.
Splendid. Thanks. Thanks for that.
Okay. Hugh? Oh, you've just muted yourself. You were unmuted.
Oh, okay.
Good job. I didn't hear you talking under your breath, eh?
Yes, don't need to talk about that. Yes, so can you please now cover what it is that happens to us who have had the wrong type of liability order cause us a lot of trouble in the past? Because as far as I can understand it, okay, the liability orders that have enabled, for example, Stanford and Green to come to my front door.
Yeah.
I've now got the proof that what they thought they had is wrong, and therefore everything that I've said can...
And therefore they might offer to settle out of court.
I'm not going for that. I want the whole thing in court, and I want the full amount.
Yeah. Yeah, I know. They may give you the full amount out of court.
Okay.
Yeah.
Yes, because there's
no... for anything less than the full amount.
Yeah, because there's actually right now there is no point in going to court because
there is no point in going to court.
Yeah. Okay.
And tomorrow we'll know if we get these next two, because with Buckle there's one perfected judgment, so to speak, based on the same nonsense. Because we ran the same arguments. Okay, we've got much more evidence and much more law to support us now than when we started with Buckle. Okay. But now with this judgment, that judge tomorrow has to set aside both of those orders, otherwise is discriminating against Buckle.
Yeah. So a friend of mine has sent the PK notices to the enforcement agents.
Yeah.
Okay. So he's done that, and now he's in a position where I believe he can now place a claim.
Now this is going to, okay, I reckon it'll take them 3 to 6 months to sort this mess out. Okay. So what everybody's got to do is get their claims in as fast as they can.
Yeah.
Okay, because it is not it's time limited. The only way they can enforce now council tax is by having a perfected court order. Okay, so James, as soon as Jacobs contact you again, we need to put in the next claim against Jacobs. Okay. Yeah.
I've had nothing off them yet.
Well, if we get anything off them, straight away we put in another claim. In 3 days, Brian's putting in 2 claims against Jacobs. They all set up, all the paperwork's in place. If anybody else has got enforcement agents, you've got limited time now. You do not tell them you want to perfect the judgment. Okay? You just tell them what they've got is not lawful. Okay? Let's sue these buggers as much as we can. whilst we still get the chance.
Yeah.
Okay. Right. So basically, what's going to happen is, like I say, they are being forced now, despite the fact that in my judicial review and Jamie's judicial review, we've got this point. What is a liability order made by the court? Okay. We've now already got the answer from the county court. So Jamie's already, sorry, Darren, not Jamie. Darren's already, that point's won on both judicial reviews already. And it's totally unravels the latent judgment into simple English and the COFA judgment. To enforce council tax, they must have a perfected magistrate's order, including the names of the decision makers. And that's where the other part of the strategy comes in. Just remember, I've been saying this is a game of chess. This is not a silver bullet. What do we want? We want the rule of law. So by having the names of the judges who are making these orders, provided you've asked the right questions to the court and submitted the correct paperwork and laid your foundation, this is going to force the constitutional issues into the magistrate's court. Whether we have judicial reviews or not. Okay? And the way that it's going to force this all into the court is the oath is to what? Law. Law, you got to understand what is a claim under statute law. It's a belief of a right of one party and a duty or obligation by another. The government is the one that believes it has a right, and whoever they've got on the other side of the equation has a duty to perform and is obliged to perform. That there in law is unknown. There is no such thing in law where one person can impose their will on another. So therefore, in law, what is going on here? It's called an equitable claim. The law knows how to deal with equity, a person's belief. So statute law is nothing more than a belief. They have a belief, statute gives them a right and gives you a duty, obligation. It's their belief. However, when it comes to law, they must prove joinder. And they can't. With property, unless somebody has a legal or an equitable interest, your home is your castle. Okay? An equitable interest or a legal interest. A legal interest is one which has lawfully been created by the court. It's legally enforceable in the public. So when they provide you with a perfected order, then they do have authority to enter your castle. You need to deal with the problem. Okay? So in equity, they will be bringing their equitable claim. And guess what a charging order is? It's an equitable charge. They know that that's the only way in law it can be dealt with. What is the judicial oath to? Law. What is law? Law is common law precedent, stare decisis, logic and reason applied to the evidence before the court. It's not statutes. Statutes are not law. They are merely a belief. And very, very few in the legal profession even have an idea what equity is They only think equity is how much money have you got in your house. That's the only thing they understand by equity money. However, the courts of equity, when you're talking about equity, are courts of conscience. What is right and what is wrong. Okay, so is your belief right or is your belief wrong? And then you will get an equitable remedy. Okay, so equity is what every judicial office holder must uphold. They have a duty to it. They've sworn to it. That is your contract. It's a statutory obligation they have to you. And it's a lawful obligation. My word is my bond. And in statute, under the Oath Act 1978, Section 4, you statutorily bind yourself to your oath, whether you were sitting on a stone which was supposedly from Scotland or whatever, whether you're wearing the right clothes, whether you're sitting on the right or wrong chair, it matters not. Your word is your bond, not only in equity and common law, but also in statute law. The oaths are statutory. So they are legally enforceable contracts. Okay? And they will tell you, oh no, it's only ceremony. Oh, it's only this. Sorry, it ain't. The Oaths Act, either statute is law, if you're claiming that, and it says it's binding, and you get paid out of the public purse, so you have consideration, intent to enter legal relationships, you have offer, you have acceptance, you have every ingredient of a contract, because you're also doing it knowing the terms. They're not difficult terms. I will act according to law, so that you can't claim you didn't understand the terms. Okay. And therefore it's a legally enforceable contract. None of this nonsense that oaths are, and if you read on Parliament's website, you know, oh, isn't it a wonderful day when the MPs make their oath to what? Law, i.e. they have bound themselves contractually to uphold the law. They're not above the law. The judges are bound to law, their oath. The monarch is bound to law, the monarch's oath. So you've got the executive, the legislative body, and the judiciary all bound to law. Nowhere does it say democracy or the will of the...
Whose law is it?
The law is very clear. It's the rules of equity which have prevailed over the rules of the common law since 1615 and is very clearly expressed as stare decisis, horizontal stare decisis, and vertical stare decisis is the only way that you can treat everybody equal under the law. And that is our legal system in this country.
It is but it is also the law of the subject.
It's got nothing to do with the subject. All are equal under the law. Equity is substance over form. Okay? So go back to Gina Miller. Go back to Gina Miller. She took the Prime Minister to court. Okay? Yeah, Gina Miller might have been financed and have influence and all of that, but it's one person. We are all equal under the law. That one person beat the Prime Minister.
It is our birthright.
Of course it's our birthright, the truth. That's what law is about.
And we are the subject.
What do you mean we're the subject? I don't get it.
As in, when the king gives his oath,
we're not the subject. The king says he will rule us according to the people's respective laws and customs. We're not subjects or anything. We are all.
I don't mean we're subject to the king. I mean we're subject to the law, which
correct.
Everybody
is subject to the law. Yeah. Whether you're a judge, whether you're an MP, whether you're the Prime Minister, whether you're the king. And the Crown Proceedings Act 1947 reaffirms this as well.
Yeah, and they have a contract. That is their contract.
They have a contract with us, and it's because of breach of contract that you have a remedy in the courts. Now, the judges don't understand this.
And we have a contract with law, the law, our law.
Correct. If any of us breaches the law, according to the law, we must provide remedy.
Yeah. And
There's
their law
it's
is
simple.
statute law.
Sorry?
Their law is the law that they made plus
No,
our
their law, statute law is private contract. That's law
Yeah.
between them. So Articles 1 and 2 of the Bill of Rights says, when we in Parliament say something, Mr. Executive, okay, and that's confirmed in the first promise of the Coronation Oath Act, I will govern using statutes in Parliament agreed upon. It's that agreement which creates the contract. So that's why, if you read the introductory text of Acts of Parliament, it's a contract.
Yeah.
By and with the advice and consent of the Lord Spiritual, Temporal, and Commons, the wonderful Majesty, by with the advice and consent, by their own free will, etc. Just read the text. That is a common law contract. That contract is how Articles 1 and 2 of the Bill of Rights works. It's by contract that the King follows Parliament as a second source of law. Royal prerogative derives its authority from the common law, from the people, because we're all equal under the law there. So the contract is to govern us according to our laws, i.e. the common law is one constraint on royal prerogative, and Acts of Parliament by contract, common law contract, are a second source of constraint. Therefore, if you read Article 13 of the Bill of Rights, it tells you the job of an MP. It's got nothing to do with imposing their will. It's about, if you have a grievance, you go to your MP, and their job is to go to Parliament and get remedy. So in one way, we have a route of remedy through Parliament. If Parliament don't work, then we can go to the courts. We have two ways of getting remedies when we're wronged. So whether your MP's name is pulled out of a hat, whether there's elections, whether you pick them by age, whether you pick them by who can roll down the hill fastest, is irrelevant. Their job is expressed in the Bill of Rights, what their job is, to amend, strengthen, and preserve the law. They can do nothing else. So, so basically, that's the structure of our legal system. That's our constitution. Quite simply, the search of truth. The truth is our constitution. Logic and reason apply to the evidence before the court. That's how simple our constitution is. We are all equal under the law. Nobody's above the law. Okay? But that would make it just far too easy. Basically, by forcing out the names of the magistrates, our paperwork says, and the duty in Lord Diplock in Attorney General versus the Times in 74, that judgment explains what the court's duties are. It's a place where anybody that's got a dispute can go to, which is neutral and unbiased, and only rules upon the evidence before the court. And so, very, very simple. The whole structure of our constitution is so simple and so fair and so just, but nobody knows how to use it. And that's what we're changing. So what we're doing is, in our reply to the complaint, i.e. we've got the court summons, and by the way, the court summons also within 3 to 6 months will have the issuing judge's name on there. It's no longer going to be just a legal advisor. It's got to be a judicial decision. Why? Powers 2018 says so. We've pointed out to the courts that admin and enforcement regulations say it must be a magistrate, a justice of the peace. Powers says you can't do anything other than what's in there if it specifies something. Because it says justice of the peace, summonses must be authorized by a justice of the peace. Somebody's got to put their name to that summons, who is under judicial oath. And the question's going to be, in accordance with Nicholson, please show me how you used your reasoning based upon the evidence before you to determine that the summons cost was lawful. Reasonable.
Mark, can I get on that point? Okay, so
Yeah.
the summons, if the council does its job properly, as it should do,
Yeah.
okay, it should be submitting our submissions
Yes.
to the justice of the peace,
Correct.
for the justice of the peace to look at it
Correct.
and decide for themselves, wait a minute, you don't need to go to court on this.
Correct.
You need to avoid going to court. Sort this out with your legal department.
Correct.
Yeah.
But we know they don't do that. So 2-3 days before you go to court, you make sure you serve the court your reply to the complaint. And in the reply to the complaint, they cannot now only deal with statutory box ticking. They will be forced under their oath to deal with the constitutional issues. If they don't, guess what they're doing? Any suggestions?
Perverting the course of justice.
And more specific?
I don't know. I
We've
thought
just
that was
talked
enough.
about the oath. What's the oath?
To law.
It's a contract.
Fraud.
Okay. So if they do not deal with the constitutional issues, guess what? We have a statutory remedy in the Courts Act 2003. Okay, and we're going to be telling the magistrates this. If you don't deal with the constitutional stuff, guess what? Controlled find, immunity. And let's look at what it says about immunity. So, protection and indemnification of justices and justices' clerks, i.e. legal advisors. We've got you here as well. Section 31, immunity for acts within jurisdiction, i.e. act within your authority, no action lies against you then. Okay? Immunity for acts beyond jurisdiction, i.e. you have a duty to deal with the constitutional issue to determine if my property, where the council has no interest, equitable or legal, how on earth does Parliament think they can still make a claim against that in law? Okay? If they do not deal with that in the magistrates' court and start dealing with these constitutional issues, guess what? We have submitted them all the paperwork. So by them ignoring the paperwork, guess what? They're acting in bad faith. Therefore, we're going to start suing the legal advisors, the magistrates, if they don't step up and do their jobs and stand up against Parliament, which is their job, to protect us, the people, from tyranny.
But wait a minute, Mark. So, for example, my section 111 for 22-23, where we were literally railroaded in a most outrageous fashion.
Yeah.
This is proof that they acted in bad faith.
Correct. If you point out to them what their job is, and they choose to ignore that, That is your proof that they act in bad faith, and therefore, in accordance with the Court Act, you sue them. And the same thing with the legal advisors. If the legal advisors do not put the court with relevant law, they need to rebut your law with a higher authority. That's the only thing that can beat us, what we're doing. Okay? They need to show us why our reasoning is wrong. And that way, the authority we rely on is wrong. If I'm wrong, I'm wrong. Show me. So far, in the 3 years we've been doing this, no barrister, no solicitor, no judge has been able to show us we're wrong in law. Okay?
Yeah.
So that's the significance of this, what people think is a waste of time and that we have no idea what we're doing. This is huge. And then if we talk about manifestation, with manifestation, how do we change the future? If we want to change the future, we've got to change our thinking today, because we got here today with yesterday's thinking. So everything starts with a thought. The thoughts get expressed in paper. We've been through that exercise. And now we're fine-tuning it incrementally. And it's only through technology that this can be done. No way is it possible for any human or group of humans to do what we are doing. It's technology that is now finally allowing all these contradictions to be found, to find out what the law should be and how we resolve all of these issues. So thanks everybody who's been a part of this journey so far, because guess what? We've got the ball rolling. Okay. Now it's just a matter of time. Tomorrow, in theory, we'll come out with 2 final charging orders discharged. Otherwise, we'll be coming out with what? A claim for discrimination under the law. So we win either way. Doesn't matter what happens tomorrow. Okay?
What's happening tomorrow and where?
Tomorrow's Buckle's sales order hearing.
Edmonton County Court,
At
North
10 o'clock in the
London,
morning.
10 o'clock in the morning.
10 o'clock, thank you.
Now, if tomorrow the judge does his job properly, or she does her job properly, that's your 3rd thing. Okay? There's something about
Mark's hoping it's going to be DJ Cohen, because DJ Cohen, the last time
I would
was
love
in
it to
front
be
of
DJ
him,
Cohen.
when he said,
I would
I've
love
seen
it.
hundreds of these liability orders, hundreds.
Thousands. DJ Cohen, in his judgment, actually said he's seen thousands of these. Well, mate, just think about those thousands of people who you have caused harm. Okay, I think, Brian, was there anything else that we wanted to talk about? Oh, the other thing is, there have been loads of naysayers out there, okay? People need to understand human behavior, all right? Human nature hates change. And unfortunately, most of us live very strongly in the material ego side. We do not like our beliefs challenged. And when you challenge somebody's beliefs, and I strongly suggest people watch Matthias Desmet and David Shirolambis. Go and watch some of that to learn about human behavior. When you challenge somebody's belief, most people actually don't know why they believe something or why they, have a particular viewpoint. However, when you challenge that, okay, what you're doing is, if they cannot rationally defend off that challenge, i.e. apply logic and reason to evidence, okay, it turns them into fight or flight mode, self-defense. And when we go into self-defense, we shut down and are in survival instinct. We've got to protect what we've got. And you will never get through to them. Well, there are very few circumstances you'll get through to them. So what's happening is, with what peacekeepers have done and the approach that we've taken has never been done before. You've got lots of people who preach out there, you know, all sorts of stuff, where if you sat down rationally, you can work out for yourself that it's just, no way, this is just nonsense. So, you know, take the justitiae v trust. That must be about the most stupid thing that anybody has come up with. The justitiae v trust. You get people saying, oh, it's a big pot of money, and if you don't claim it in 7 years, you know, somebody else is going to use it, and blah, 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 blah. Just think about the rationality of that. Some people even say your birth weight in gold is put in there. And some people even say this gold gets put in the Vatican vaults. So there's all the gold in the Vatican vaults. So just think about it. Who is putting this money in there? Where are they getting this money from? Why wouldn't they want to give it to you if they can't use it for 7 years? And if they can use it after 7 years, why aren't they spending it? And if it's gold, where the hell are they getting all this gold from? There's over 8 billion people on the planet. There's not even 8 billion ounces of gold on this planet, to the best of our evidence, let alone your birth weight of 8 billion people. Okay? So just simple logic, reason tells you, hey, it's just not real. You know, this is fantasy land. But people hang on to beliefs. And the problem is, we brought up with superheroes. You know, Superman, Batman, Batwoman, Spider-Man, this, that, the other, Donald Trump, you know, this president, that president, they're all going to fix it for us. The charming prince is going to come and sweep us off on his white horse. There's always the hero. That's what we are programmed to. So that programming, when you realize you are the hero, you are the one that needs to change. And that's what creates the new reality for tomorrow. And so with the naysayers, what they're doing is, and you need to learn to deal with your emotions with this stuff. Okay, because a lot of people get angry and, you know, oh, look what they're saying about us and all of that. Hey, listen, you've chosen to stick your head above the parapet, all right? You are challenging the belief system. Statute is law. We all know they've got nothing more than violence, the monopoly on violence. And they'll steal what the hell they like, because it's no different from a mafia operation. Okay? Human Rights Act tells us that. You have the right to private property, except if the government feels that they want some of it. And if you don't give them what they want, okay, then they will take what they want. So we've moved back to the tyrannical state. And that's the way the pendulum works. Everything's in cycles. What Parliament's forgotten is, what is their purpose? The whole revolutions started, I've said before, with knowledge filtering down from 1% to 10% of the people with the printing press. That resulted in 300 years of revolutions. We now have technology globally connected, where we can instantly exchange knowledge and experience. What took 300 years is not going to take 30 years. Okay? So it's just going to go faster, this change. And it'll just reach a tipping point like this. And things will start to change quite quickly. I reckon another 4 years if they're lucky. I don't even think that they've got 4 years. And if you want to speed it up, I strongly suggest go through the course materials. Joe DeSouza, he's just gone through and put up a comment that maybe one of those videos, the legal professional's duties, rights, and obligations. And in that video from 2021, exactly what I'm saying now applies. I said it then. Okay. And I don't want to talk too much more about it, but basically, one person changes 10, 10 changes 100, 100 changes 1,000, 1,000 changes 10,000. 10,000 changes 100,000, 100,000 changes a million changes 10 million, and 10 million changes 100 million. Basically, we just need to influence 9 people, 9 levels. And that there, okay, is how easy it's to change. But it always starts with you. So the aspects is knowledge. Knowledge builds confidence. Do you think I'd be doing what I'm doing if I didn't have confidence in what I'm preaching? It makes sense to you guys. But please, please, please go through the courses. It'll give you more knowledge. We all have work. We all have stuff to do. Go through a module a night or a module a week. The whole idea of the knock-knock process is to apply that knowledge so that you can see it's a simple scientific process. Once you understand the steps, let's just rinse and repeat for a different set of facts. It's the same thing. And that there will take you a hell of a long way in a relatively short time. And that there will change everything. People are taking baby steps forward, testing their existing belief systems. And before you know it, somebody's half a mile ahead down the road from you because you didn't have the courage even to take a baby step with them. But once you see that they're okay, half a mile ahead of you, you might take leaps and bounds because you have faith that what they're doing works and is a better future. And this is what we need to do. We need to lead the way by example of the new world that we want. We want the rule of law. All we're asking is for the government, for the judges, for the MPs, all of them. Just do your job according to law, as you've promised. Not a big ask. So the whole change already is, I mean, I can see signs all over of the change. Once you start seeing, it's a game of chess. Sometimes you'll lose a piece. Sometimes you won't. Sometimes you may even sacrifice a piece. Sometimes you won't. But basically, this game of chess, where the victory, checkmate, is the rule of law, they know they've lost the game. They know they can't stop what's coming. And you can see so many places they're getting more and more desperate to try and cling on to what they know. But remember, human nature does not like change. So that there's sort of what's happening with, if you look at the alternative truthers, many of them actually derive financial income from what their beliefs were and what they're teaching. And we, the little kiddies, the idiots, the fottlers, even with the Ministry of Justice, whatever people want to call us, and no idea what we're doing. Okay, remember, some of us were there. I've been down every rabbit hole there is. Okay, so let's not be harsh and overcritical of them, but just like the alcoholic, okay, you must not bang your head and frustrate yourself with them, because that's the worst thing you can do. With an alcoholic, stopping them or trying to protect them from destroying themselves, and destroying themselves means reaching such a low that they accept they must change the way they behave. Okay? You've just got to let them find that point themselves, because you might be able to stop the lift. Okay? But it's still going to go where it's got to go to. So for everybody, they need to find their own motivator to change their belief system. And until they find that, they will never have an open mind. And they will always behave in flight or flight, survival instinct, to protect their existing beliefs. So don't worry about what others say. You know what's true to you. Follow what's true to you. And that's where we find the common reality. And that common ground. And with that common ground, we are going to be manifesting the rule of law within 5 years. It's going to get worse first, because as people get more desperate to hold on to what they want, are accustomed to, and I've said to you, 90% of the legal profession and judiciary will not be needed, because 90% of this rubbish that gets to court, okay, should not even be going anywhere near a court. All of this, the vast majority, should be resolved in private. But they have the monopoly. What's different is we sharing knowledge and experience for free. We do not have a conflict of interest. The legal profession has a conflict of interest. I really do think that we need to make a really good video on this to highlight their duties. Like we said, their duty is to the rule of law, to the court. So I'm talking about solicitors, barristers, and legal executives. And then comes their client. Okay? So it's not about protecting your client at all costs. It's about fulfilling your duty to the rule of law and to the court. And that means if your client is wrong, you tell them. And you tell them, if you want me to go to court, I've got to tell them why you're wrong, in the wrong. Okay? We grant them a special privilege of a monopoly. We entrust them with the rule of law. So now we need to be adults about it and hold them to account to the rule of law, just like everybody else is, because we're all equal under the law.